Hi, I'm Rich Burke from Clifford Law Offices, and in this video, I'm going to discuss some of the main issues that are involved in evaluating a COVID-19 business interruption claim for many of your clients. As all of you know, the COVID-19 pandemic and the resulting shelter at home and closure orders have had a devastating effect on many small businesses and especially restaurateurs. And I'm sure many of your clients have contacted you about the possibility of seeking some type of compensation or making a claim for the losses they've experienced as a result of being unable to continue the operation of their businesses. Many of these clients you will find have business loss insurance policy provisions in their normal insurance coverage that they have for their business. And the first thing you need to do in evaluating a claim like that is to get the policy. As is the case with all claims involving any type of insurance, the specific provisions of the policy become very important. Also in relation to that, and while doing that, certainly make sure that your clients have put their insurance carrier on notice. And by that, I mean that they've informed them that they have experienced a loss and that they are making a claim for that loss under the coverage that they have. Also, if your client has already done that, you want to obtain the denial letter that they may have received. Many clients may have already contacted their insurance company, and as I have seen in a lot of instances so far, insurance companies have been rather promptly denying such coverage. So if there is a letter that your client already has denying the claim, you want to get that, because that will set forth some of the rationale of the insurance company, and that's something that you need to evaluate as to whether it is an appropriate interpretation of the policy provisions. Then in terms of the actual content of the policy, there will be several important topics that you want to look for. One of them is what constitutes a covered loss. And you'll find in many of the policies that that expression is equated with or interpreted to mean a physical damage or a physical loss to the property of the business. And that will be expressed in differing terms, and it's important for you to evaluate exactly what language and what words are used in describing what constitutes a covered loss. I think that you will also find that most insurance companies, if your clients have received a denial letter, are taking the position that the COVID-19 virus and closure orders that have occurred in conjunction with the spread of this virus and in an effort to prevent the continuing spread are something that the companies do not believe falls within their definition of physical damage or a physical loss to property. So that will remain a very contested issue in these type of cases, and will require evaluation of the specific language as well as the specific facts and circumstances of your client's business and the type of loss in order to make an effort for them to bring their particular circumstances within the confines or within the terms of their policy. Another very important aspect of the insurance provisions that you want to look at, it relates to losses due to civil authority. In most of these policies, you will find some reference to business losses that have occurred as a result of the entry of an order by some civil authority office or figure that has closed or reduced the operation of their business and therefore resulted in significant losses. And Obviously, Governor Pritzker here in Illinois and in most other states have issued orders that required closure of businesses and particularly restaurants. And therefore, your clients likely believe they have had their business essentially shut down based on the order from a civil authority. And so you want to look at that and see if you can bring your claim within the provisions of that policy. You'll find in some instances, however, that the action of the civil authority in closing down a business might be related back to what they considered to be a covered loss, which in turn includes physical damage or physical loss to property. That again will become a very contested issue. And in the denial letters I have seen from a wide variety of insurance companies, most of them have taken the position that the action of Governor Pritzker and closing businesses is not something they deem within the definition of their policy provisions as a basis for a covered loss. That too, of course, then obviously will be the subject of much ongoing and continuing debate and discussion and very likely litigation. Another important aspect of the policy you want to look at is any exemptions. And as many of you know, insurance policies are always replete with various types of exemptions. So you want to look for ones that specifically relate to the business loss circumstances. And some policies may actually have an exemption for losses due to a virus. Those have come into use perhaps just in the last few years, but many of the policies, even if they don't have a virus exclusion, will have other types of exclusions that relate to contaminants and pollutants and bacteria and fungus. And you may find that insurance companies also consider the virus, the COVID-19 virus, to have resulted or to be related to the one of those types of conditions, such as a pollutant or a virus or a contaminant, and therefore will deny coverage as well. So you want to establish or talk to your client about establishing how his or her circumstances differ and do not preclude him from getting coverage. And then one of the two last main topics I just want to mention is if there is a good basis for coverage and a good argument for your client obtaining coverage, I think you need to be thinking about what their damages are. And damages in these cases sometimes are limited by time period within the policy itself. And I've seen them ranging from 30 days to 60 days to up to a year. So you want to be mindful of what that time period is that for which they can seek coverage. And secondly, you want to advise your clients to get their accounting records together. Most of the language refers to actual losses due to the business, or actual losses due to the closure and the virus, and you need to establish that ultimately as to monetarily what that amounts to. Finally, then you should think about the type of cause of action that might exist. Certainly one option might be a declaratory judgment action in which you seek a determination that the policy is in fact applicable and request to have its terms enforced on behalf of your client. You might also consider breach of contract actions or review the language of the policy and your client's particular facts in relation to whether perhaps there's been any misrepresentation or whether there's any violation of consumer protection laws in the denial of the coverage. So those are some of the main topics just for an initial evaluation of business interruption claims on behalf of a client. As always, insurance policies are usually lengthy and may well have a lot of other provisions that either limit or possibly expand coverage. So, of course, you'll want to evaluate the entire policy. But hopefully these thoughts give you a start on trying to do a good analysis on behalf of your client to at least get a general overview of whether or not there is a valid claim for business loss. Thanks for watching, and hopefully these points are helpful to you. And if you'd like more information about this topic, please visit the ISBA website. Thank you.